Welcome to the first ever AI conference hosted by the ACC National Capital Region chapter. First, we'd like to thank you for your flexibility today. Our first program scheduled for 9 o'clock this morning needed to be postponed due to a last-minute emergency. We do intend to reschedule the program, and please be on the lookout for a message from the chapter regarding exactly when that will occur. Now, today's event is hosted by the chapter's Technology and Intellectual Property Committee, Ethics and Compliance Committee, and Employment and Labor Committee. We'd like to also thank the law firms Polzinelli, Davis Wright Tremaine, Williams and Connolly, and Haynes Boone for sponsoring this event. My name is Steve Tibbetts, and along with my Tech and IP Committee colleague and President-elect Angie Stinson and Ethics and Compliance Committee Co-Chair Karina Vollmer, we wish you a warm welcome. Thank you for joining us today, and we are excited to continue our AI-oriented programming.
Good afternoon, everyone. ACC National Capital Region and our sponsor, Polsinelli, are pleased to present this webcast program, AI and Tech Transaction Risks. Those of you who've been with us for the day have met me before, but for anyone new, I'll briefly introduce myself. My name is Angie Stinson. I'm an Associate General Counsel at the National Student Clearinghouse, ACC NCR President-elect, and a member of the Tech and IP Committee, one of the three committees that helped organize today's conference in collaboration with the Ethics and Compliance and Labor and Employment Committees. This program is being recorded. The presentation may be downloaded from the link in the reminder email that was sent to registrants yesterday. If you didn't receive the email, please check your quarantine or spam folder. A copy of the presentation will also be placed in the chat, so you may download it from Zoom. If you need a copy of the presentation sent directly to you, please email Janine Wynn. If you've dialed into today's program by telephone, please note that you will not be able to receive CLE credit. To comply with Virginia CLE rules, you need to be logged in using your name and company. If you have any trouble with sound, you're welcome to turn on the captions for a running transcript. Look for the tool to enable captions at the bottom of your screen under the More menu. This program will last approximately 60 minutes. You may pose a question or offer a comment at any time during the program by using the chat. The panel will address questions as time permits. To ensure that we have sufficient time for the prepared content, the panel may need to hold questions until the end of the program. All remarks made by today's panelists are their own opinions, do not constitute legal advice, or necessarily reflect the viewpoints of their company, firm, or of ACC NCR. And now it's my pleasure to introduce the two panelists for this program. Ileana Peters is a shareholder at Polsinelli PC, where she focuses her practice on privacy, cybersecurity, and information technology. She provides strategic counsel to clients on navigating complex regulatory environments and managing the legal risks inherent in AI-driven technology transactions. Courtney Welton is a global executive with extensive expertise in technology transactions, AI governance, and cybersecurity. She previously served as global general counsel for Motorola Mobility, managing multi-billion-dollar strategic deals through its ownership by Google and Lenovo. Most recently, as senior vice president and general counsel at Allstate, she led the company's enterprise-wide AI governance, ethics, privacy, and compliance frameworks. And now let's begin the program.
Thank you so much, Angie. Thanks to everyone for joining us. We really appreciate the fantastic attendance, as I know ACC does. It's always a pleasure to talk with all of you about these challenging topics, and we're excited to have this conversation today. I am going to be running for a flight here very shortly after our conversation, so we do encourage you to use the chat function. So if you'll pull up that chat function, you can do that by using the toolbar at the bottom of your screen, hit chat, which will come up to the right-hand side of your screen, and you can add chats to our conversation here. We'd love for this to be a really interactive and fulsome discussion. Courtney and I have talked about this topic a couple of times now, and we're excited to have that discussion with you as well now. So we always have plenty to say on this topic, but obviously would love your involvement too. We will ask a couple questions for you as we're having the discussion. If you'd like to answer, obviously no obligation to do so. Please feel free to use that chat function. We'll try and reflect some of your answers in our conversation as well. So as Angie mentioned, my name is Ileana Peters. I'm a shareholder at Polsinelli. I've been with Polsinelli for about 8 years now. I focus my practice on data privacy and security, and particularly complicated data sharing projects, including with regard to AI. I never contemplated that I'd be spending this much time at this point in my career on contract negotiations related to vendor relationships, but here we are. And these are getting particularly complicated these days related to the data rights associated with AI tools. So we're excited to talk with you about that today. I am super excited to have Courtney for this discussion as well in my corner, because she and I, as I said, have had this discussion more than once now. And so Courtney, please jump in and talk with the group about your experiences here a little bit and our discussion today.
Absolutely. Well, you got the formal bio, so I won't go there. But what I really want to bring to the table is the in-house perspective. And I think we think about AI and where it's evolving and how fast it's evolving, and how the law isn't really exactly where all of us would like it to be, and maybe not as developed as we'd like it to be. That's exactly when contract negotiations and also the partnership between outside counsel and inside really is powerful, because you have to make sure that you're thinking about these things in contractual terms, because the law may not be doing it for you. And a good way to do that is to partner with people like Ileana and others who really know their space and can benchmark across and help you think about it as an in-house expert. So what I hope to do is just kind of give a perspective on how people are thinking about it in-house. And obviously, Ileana and I will, try to give you both those perspectives. But I would just really encourage you, as you think about this space, to think about really thinking about broadly how to make sure you're thinking about these things, because no matter how good we think we are, no matter how long we've spent at the edge of emerging tech, and I've spent over 2 decades, it's still a place that's continuing developing. And the best way to do things well in that is to get with other smart people and try to work towards the best possible answers you can find when there's gray areas. So with that, I'll turn over to you to start the slides, but I really hope that people interact and ask questions in the chat, and hopefully we can be as responsive as possible. And then both of us are willing to take any questions after the fact, although it won't be live. You're welcome to reach out to either one of us, and we'd be happy to engage with you on it.
Yeah, absolutely. Couldn't agree more already with Courtney that this is a super challenging area, and you always will just want to have a really robust team. And of course, please feel free to reach out. You have our contact information. We are more than happy to have additional conversations offline with you if that would be helpful. So what we really want to do today is take some time to talk more in depth about sort of what the risks are with AI, particularly in your vendor relationships. So, just sort of introducing the topic, which I know you've already had some discussions about, and, you're probably dealing with this much more frequently now than you were even, a month ago, 3 months ago, certainly a year ago. I have a lot of clients in the healthcare sector, and frankly, we've been dealing with AI tools for decades now. AI tools in the healthcare sector are not new, but there are iterations of AI tools that we're dealing with now that are new and that are much more challenging from a data perspective. And so, it's really important when we start to have these conversations that we start from the beginning with the tool. And what the tool is, because that's where the risk will be. And so having a really robust conversation about what kind of tool we're talking about, what is the goal of the tool, what is the purpose of the tool, why does our business team or client team or whatever team is that HR team, whatever it is, the team that wants to implement that tool in the enterprise, why do they want to do that? What is the specific reason? And so really effective legal advice depends on the specific facts related to the tool that you're working with. that tool may be, it may be a very simple tool, in which case the risks are probably pretty low. Maybe a pretty complicated tool. We're seeing a lot of those lately, and the risks just grow exponentially. So really trying to understand and have the context for the tool, the purpose of the tool, and the goals of the tool, and the use of the tool within your enterprise is really key to every single discussion. I would highly suggest, as the slide does here, don't start with the paper. You really need to start with the conversations with your teams about what this tool is, what it does, and why they want to use it. Because that's going to be key for how you look at the paper. And particularly in my recent experience, what is not on the paper, which we're seeing a lot of. A lot of what the risks are not appropriately reflected in the paper because the relationships are not understood correctly. So if you just look at the paper, you're not going to get the whole story, number one, and you're not going to be able to address the legal risk sufficiently, number two. But Courtney, add here to our conversation and talk about sort of what you're seeing in this respect as well.
Yeah, I think what's probably on the mind of most of us who do counseling work with our business clients is how do we get them to understand that it could be the same tool across, we'll call it 20 different companies, but it could either be a competitive advantage given the context, or it could become a regulatory problem given the context of use. That is really hard to explain to technologists and to business partners. When you do it, though, that is when they start to understand that in order for you to push your company towards a competitive advantage and away from creating a regulatory problem, you really have to have the full picture to do that. And I think we just have to be really clear with people. I've seen this, way before AI and the iterations of AI now. Your business partner comes up, they say, hey, all of our competitors are using this. Why can't we use it tomorrow? Why are you so slow? What's happening? And again, you're going to really have to, yes, I want you to be fast. I believe in that for in-house counsel. But at the same time, the use of it and the outcome that you're trying to drive and what you're trying to solve really does create the risk and really does matter for the way the law is looking at it. And increasingly, we're seeing in the court systems and different cases that are starting to go through that they're looking at that aspect of it. So context is going to matter. It's a hard thing. I'm not going to tell you it's easy to describe to your business partners and your technologists why it might matter in your company, in your context, and why there might need to be a little bit more thought into figuring out a way to develop it where you need it, versus what they may see somewhere else. And so you're going to have to really focus on that relationship piece and making sure they understand why you're asking for context. And then the other piece of it is, you need them to understand that the law is very gray here and it's still developing. And when that happens, as I mentioned, that's when contracts are really important. And the only way to make contracts make sense and are useful to your company and really make sure that things are allocated correctly, that risks are allocated correctly, is if you understand it in and out. And so that, if you kind of have those conversations and have them understand where you're coming from and why you're coming from that space, I think they'll get there. But it is hard because things are moving rapidly. The technology is moving rapidly. The opportunities are huge and very good ones for our customers and for various businesses. So we have to keep moving. But at the same time, we have to make it clear to our business that without context, we really can't set up these contracts in a way that protects us.
Right. Absolutely. Couldn't agree more. And so I think, the message of this slide is relationship building, internal relationship building, so you can understand context associated with particular documents, but also external relationship building. We'll get to that a little bit more in terms of what those conversations are going to look like that you have with your team and that you and your team then have with your external business partners, depending on what those relationships look like. Next slide, please. So when we have these conversations, again, to just drill down more, we have sort of a set of initial steps, and we'll get into this more in the presentation more specifically. But again, what we're looking for, and to Courtney's point, is the the law here is very much driven on the purpose of the tool and the data in the tool, the current law. And so really understanding, which members of your team or which members of your consuming public or whatever the case may be, who is going to use that tool and for what purpose. And that again, to Courtney's point, is key for how you have that context for understanding the risk. So if it's an internal facing tool only, the risk may be very different than if it's an external facing tool and consumers are going to be using it, or it will be used to collect consumer data, for example. So these are, very different purposes, very different audiences, and really understanding that as a first step helps you create that context. The use cases are also really important. So understanding each use case, because the legal analysis is going to differ based on the use case. In other words, if you've seen one AI tool in one situation, you've seen one AI tool in one situation. If you try and take that same analysis and say, okay, we've approved this tool, we can now use it across the enterprise for a variety of purposes. Unfortunately, that's not generally how these tools work, because the analysis is so specific to a use case. Who's using it for what purpose? Who's going to be directing the use of that tool? What data is going to be in that tool, et cetera. And so if that changes, if the audience changes, if the user base changes, if the data changes, it's going to change the analysis of the tool. And so, just as a first piece on this slide, that's really what we're dealing with is how do we get the context to negotiate the transaction by understanding and developing specific use cases for all of the ways that this tool may be used in the enterprise. Courtney, do you have thoughts before we sort of move on to, the next pieces of this slide, kind of how do we need to talk about or think about use cases and developing that internally and with our teams?
Yeah, I mean, I think, it's a really good time to partner with risk partners. If you're in heavily regulated, you generally have a separate risk group. They do a lot of work in thinking of things from low, mid to high risk, and they're doing it with your board and others. And so they have a framework already that you can use. We certainly did that at Allstate. But the things that you mentioned here are what flip it. That said, it could still be different in certain circumstances. So something that's external in a company that doesn't deal with financials, doesn't deal with healthcare data, doesn't deal with some of those things, might not be that high risk. On the other hand, if you're in those spaces, like Ileana works with her clients, it becomes very high risk fast. And so then you have to put in guardrails and you have to be even more specific on use cases. So it really does depend on sort of thinking about it holistically and then building out that picture. And I think it's important to think about the fact that the tool itself will change over time, which is a slightly different piece than a lot of technology before it was, because you're trying to anticipate that in the contract. And there are always places that we anticipated. If you think about how we think about indemnities in the future and IP and things like that, there's analogies for you to look at. But at the end of the day, you have to be thinking about, how do I both get specific enough from a use case perspective that I know how to contract? At the same time, I've got to make it broad enough that there's a operational ability to actually run my business with this vendor. And those two things can sometimes come into conflict. And so I think you have to take a really pragmatic approach to it. And that's where I would say getting the cross-functional group together right away. And every company has kind of a different flavor of how they might roll out technology and different products and services. Sometimes it's very technology heavy led. So the technologists lead it, and sometimes the business is in the back. Other companies, the business decides what they want to solve and what they want to do for a customer, and technologists serve them. And then there's lots of permeations in the middle. And what I think for AI, you have to do as the lawyer is really level that playing field and say everybody needs to be together, because we need to look at this holistically from the beginning in order to build the risks and the opportunities appropriately within the contract. And that may be having to work against some bureaucracy and some different ways of working within your company. So really important that the lawyers step back and understand the broader framework with which they're operating in, because that will drive, in my opinion, how use cases work out. And the other piece of it is, think about the use cases in some way around who owns them and what accountability they have. And if people who have accountability or would be held accountable for something going wrong in particular, if they don't have a seat at the table when you're thinking about this, then you have a missing component, right? So sometimes that's another way to make sure that you and your teams are thinking about, are the right people at the table helping us develop the use cases and think about the risks of them once you do. The other piece I'd say is allow the use cases initially when you think about them, try to have them be broad. Let the business really think about the problem they're solving and what they're trying to do with the technology, because there's great uses out there. Later, you can talk about whether or not that's high risk, medium risk, or low risk, but I wouldn't stop that innovation on the front end, because again, not only could you contractually mitigate it potentially, there also might be developments within the law that that may allow something that they don't today, and you'd want to unearth that and know it up front that it's a high priority when certain things change. And so make sure this exercise is positive for the business, right? It's an innovation session. It's a whiteboarding session. It's not just let's put this in a bucket that legal can go deliver on. Yes, that's how we're going to think about it when we got to go do our job. That's how we're going to execute on it. But I think if we as lawyers think of part of the innovation process and solving the problems we need to do to run our business and to help our customers, then it's going to be a more positive experience, and you're going to get more. You're going to get more from your teams on what you're really talking about. So I'd probably approach it that way.
Yeah, absolutely agree. And thanks for sort of leading us through this slide so well, Courtney. I would only add that, I think Courtney's exactly right. I'm seeing a lot more of my clients developing these cross-functional teams, particularly with AI tools, because it just is necessary. Because you have a business team that has high stakes involved with the use of a tool for whatever reason. There is so much information technology review necessary with these tools. And then, of course, legal and risk have to be involved in order to have the right conversation about whether or not and how the tool should be implemented into the enterprise correctly. So just by the nature of how the tool is developed and used within the enterprise, you have to have multiple teams involved. And to Courtney's point, it's not always seamless, because it isn't necessarily the case that these teams work together on a regular basis. And to Courtney's case, it's very use case dependent. So we're not saying that you have to have this process for every single tool that you're implementing in the enterprise. Again, you may have a very straightforward, simple tool that doesn't have a lot of risk, that isn't gathering a lot of data, or isn't interacting with a huge audience or something like that. And you don't need to involve a bunch of people from all of those teams. But in some cases you absolutely do. And it's really important to really get a good feel for what that looks like, depending on what these tools look like, based on the context, whoever brings it to you, and getting that initial context. Next slide. So again, when we're having these conversations, it's really about that, context, relationships, use cases, and figuring out, what questions have to be answered internally. How do we have those conversations to ask those questions before we even start with the paper and the negotiations with the external party? And how does that, sort of approval process and internal process kind of shape our contracting strategy? And again, from my perspective, I think it really depends on the tool. It's very much going to depend on, again, as Courtney mentioned, those use cases and what those use cases look like. But once you have a good sense of what those use cases look like, then, you really need to figure out what that process is, such that all of those stakeholders, as necessary, have a say as you enter into the next phase, which would be really attacking the paper and the negotiations themselves. But Courtney, add your thoughts here in terms of sort of how you've seen this work internally in the different companies that you've been working with.
Yeah, absolutely. Well, first of all, I'd be remiss not to say that as you're thinking about this, I'm sure you're starting to see by the questions that we've talked about already and how we're posing questions, things like, what data is being used? What problem are you solving with it? These are the same type of questions that we've been digging into from a cybersecurity perspective and a privacy perspective for years. There is a lot of overlap. It's also what anybody in heavily regulated has been working on in their compliance departments. So in order to not have fatigue from our business clients and our technology teams, I do think you need to figure out how you're going to get these battery of questions answered and have a really good framework and process built amongst those teams so that you're sharing information. Now, you may be small enough that you're all, one person's doing it or three people. But if you're at a large company like I was at Allstate or Motorola or Lenovo or Google, we really had different teams doing pieces of it. And I was always shocked when we had so many people asking the same type of questions to our business. We can't do that because that's when you start to get either conflicting answers or they just start to ignore you, right? And you don't get the context you need. So I would say as you start to think about what's your reality within an enterprise, particularly if it's a large one, you need to think of the battery of questions. It's almost like due diligence when you're buying a company. Another good analogy for you. You can't ask every question or the company will walk away and the people who are doing the deal will want to kill their M&A lawyers because they will think it's hindering getting the deal done, right? Same time, if you don't ask enough and there's some huge problem or value driver that you didn't find as the M&A lawyer, you're going to have problems, right? And so you have to ask enough. So for example, in those cases, you try to figure out, is there cross-border data? Because if there's cross-border international data, then there's deeper questions you have to ask. If there's not, you can shy away. So I think about that kind of framing when I think about this kind of getting the context and then building the governance. But I also think it's really important that, and I think this is true of all vendor contracts, and I've done vendor contracts for years, but I think it's coming to a head with AI, which is you have to know how you're going to actually implement what is in that contract, whether or not the vendor is going to be doing that obligation or whether or not you are, and it's an expectation. You need to think about it, and each party needs to understand how they're actually going to do it. And when you do that and you ask those questions, who's going to own the business decision? What data is involved? What decisions are humans still going to make? What happens when this goes wrong? How explainable is the system? What's the level of dependency on this vendor? And what would happen if there was a problem? Do you have an exit plan? What internal approvals would you need in a scenario like that? What's our risk tolerance? Are we prepared for regulator scrutiny? Do we have visibility and explainability here? These are the type of questions, and we say governance questions, that's what we're talking about, is digging into that. And when you ask those questions, you're asking it of yourself as the compliance person, as the lawyer, but you're also asking of your business, and you're asking it of your technology partners, and you're asking it of your procurement partners who are going to have to hold the people that they got a vended solution from accountable. So you really have to write those things out and figure out what's important to you and your company. And that is going to then lead you into a much easier contract to build, right? Because you will understand all those things. So context isn't just like, call it a gray thing. It's really diving into how will this work between us, particularly when things don't go well? What happens? Because that's what you have to plan for in the contract. And the only way to really do that is to start talking through scenarios and figuring out who would be pulled in those times, and then get their perspective and start scenario planning.
Yeah, totally. I couldn't agree more, Courtney. I think you're right on. I mean, I think some of this you can build into process in terms of the important questions, particularly as Courtney's been talking about. Having those questions, and we'll have some more introductory questions for you as the presentation goes on, but having some sort of reference documents for your own sake, so you feel like you have a handle on what you need to be asking going into these negotiations pretty much every single time, so you can get those context information about context your use cases, have those discussions with your teams. But also, really trying to figure out what this process looks like also can be really helpful. And I have been working with several clients on really sort of articulating what they expect this process to look like within their organizations and the enterprise reality of the process, and who is going to be involved, even to sort of the committee level and board level in certain circumstances. So I think that's a helpful exercise as well as policy to have. So the exercise itself in sort of figuring out how this is supposed to work is super helpful, as well as then having it in a written policy so that you can work from it. Next slide.
Yeah, and I'll just one thing before we move. I would just say velocity, as I said, is really important in this context from a business perspective. And so getting an understanding of if you do design it, and again, everybody's frameworks are slightly different, but if you design it around guardrails and use cases, and then circumstances change, determine in advance who has to approve something and where you have to go, and have that clear both on your side of the table and the vendors, because a lot of times it's both of you having to adjust what you originally thought in the contract. This has always been the case with vendors, particularly in technology, but I think the velocity with which we're asking people to make changes and how fast the technology is changing, it requires us to kind of break through the bureaucracy of some of our companies in advance. So that's why we mentioned in there that really understanding your approval process and what that looks like in the context of kind of the sandbox that you built so that people could go forward using the technology.
Yep, absolutely. Courtney and I have already talked a little bit about sort of all of the concerns that we see when we start these negotiations. And to Courtney's point, this is cropping up everywhere. This isn't just vendor negotiations. This is coming up in a lot of deal negotiations recently as well. So these conversations can be, and we have focused primarily on, for the purpose of this presentation, sort of vendor relationships. But you can have similar issues in transactions as well, which Courtney pointed out. And so a lot of this is transferable throughout your enterprise for different types of internal and external relationships, depending on what those AI tools look like or what the business relationship is around an AI tool, in case you're developing one, buying one, selling one, whatever that looks like. These are helpful questions whenever you are having those discussions around an AI tool. And part of those discussions that we're obviously seeing a significant piece of is the data portion of it. So, you have a lot of questions now, and where we do have robust regulation, it is not AI specific regulation, but it is robust regulation, both at the state and federal level. And to Courtney's point, we are seeing class action litigation about these issues now, related to what the data use of these AI tools looks like, and whether or not that's actually permitted under state and federal law. And to Courtney's earlier point, in some cases, international law. And so what we're talking about here are tools that leverage data by their nature. That is what they do. They leverage data. And so you must have a good understanding from the beginning of what the data relationship looks like. What data are we talking about? For which data subjects? What kind of data is it and for whom? Again, just to restate that. And how is that data being used? Is it being used in ways by that tool that are permitted under state and federal law? In many cases, that data obviously cannot be made public. In other words, it cannot go to a public-facing tool in a public server somewhere that can then be leveraged by other individuals who are in the public. In other words, if the AI tool calls out to the internet, as most of them do, and data is shared externally from your organization, that is an immediate risk issue. So that's why we often talk about enterprise versions of these tools and sort of containing the data flows. So one of the very first questions you must ask is always about data. What data is it? For whom? Where is it going? How is it being used? Is that data being used to develop new and different tools? Probably an issue. Another issue that comes up quite often is the de-identification or anonymization of data. This is a particularly sticky issue, which is why we've included it here. It's something that you should be aware of, because this is often one that isn't in the paper. In other words, when you start having these conversations and you start asking about what data are we talking about, how is the vendor going to be using our data, we are generally talking about identifiable data. In other words, it's either data that can be sensitive or not, but can identify individuals. I'm including based on simple things like an IP address that could be in scope. So when we're talking about identifiable data, obviously we have state and federal requirements that apply. However, the state and federal requirements arguably do not apply if the data has been de-identified or anonymized, which is why many of the vendors want to undertake those activities, because there is a lot that you can do with de-identified or anonymized data, particularly because it arguably falls out of these regulatory regimes. Now, the problem is that if the data owner doesn't specifically permit that activity to occur on its behalf, you may have an issue under state and federal law, particularly from a licensing perspective. So this has come up in a couple of deals very recently, one of which, in my experience, we had a situation where a client went to buy an AI tool. The AI tool did not have the correct data licenses from the data owners that it had been working with. And so the client walked away from that deal because they could not take on the huge amount of risk of a tool that was developed with data in a way that arguably wasn't permitted by the data owners. So as a data owner, you must be very aware that you must understand the permissions that you're giving to your data processor or vendor, including with regard to de-identified or anonymized data, because if that data is re-identified or unanonymized, which is becoming increasingly common in big data sets, the data owner arguably remains liable for that re-identification, for that breach. And similarly, if you are a data vendor, a data processor, you need to make sure that you have those conversations and get those licenses right, so that when you go to sell your product or you go to build on that product or whatever the case may be, you have those licenses that are correct, and that you are using the data appropriately in a way that is permitted, not just under state and federal law, but also in conjunction with your contracts, which, as Courtney mentioned, is a key piece of these discussions. So I'm going to ask Courtney to jump in here too and talk about sort of her concerns from an internal perspective on all of these data issues that we've been talking about.
Yeah, I mean, I think you've covered most of them. I do think the interesting thing about de-identification and anonymization is there's not great standards on what that means. So that does mean that you do have to be very careful, and you have to really understand the process by which a vendor says they have done that or they're going to do it, and hold them accountable to it. So I would just caution you on that. But what I would say is, beyond all the cautions, if a vendor really wants the de-identified data that comes out of working with you, they want it for probably one of two reasons. One is to improve your service, which you get a benefit from. But probably even more than that, what they want to do is be able to sell it to other people and improve services to other people, in which case they get all the benefit and you don't. And maybe even competitors of yours begin to get an advantage. So what I would think about is, this isn't just a privacy issue. It's not just an AI issue. This is a strategic asset transfer. The de-identified data set that comes out of the work you and your team and your company does in that tool could independently have value. And in which case, are you getting that value? Now, that could be that, over time, as that pool is created, perhaps you get a discount for what you're paying for the tool. It could be that they have to pay you, directly, not just discount. whatever it is, just remember that contracts at the end of the day are value makers, is the way I think of them. And they're not just to mitigate risk. You could create value. And if the vendor is really wanting this from you, there's probably a reason. How can you find a way to either create a competitive advantage, get some kind of monetary value? Maybe there's something else in the contract you can trade it for that means more to you, or a risk that your team is worried about that they feel more concerned about. But I would definitely think about the fact that this could be a value leakage area, and that there's something here that you should be thinking about if the vendor is really adamant that they want it.
Yeah, absolutely. Couldn't agree more. This data is incredibly valuable, and many businesses do not understand that when they provide rights to this data, they are just giving that value away, to Courtney's point. So it's really important that you understand what this process looks like in association with your AI vendors, particularly because this is a particularly important issue in this space. The other piece of that too is a lot of my clients are now considering indemnification related to re-identification of the data. Because again, the vendor is likely to be off the hook for that activity because they're not the data owner. So if data is re-identified and it's considered a breach, for example, then the original data owner is arguably liable, and you don't have any protection if that vendor de-identifies the data and then sells it. So all of these issues are really important, and something to think about, particularly when this is not mentioned in any of the documents that you're looking at when you're starting a vendor relationship. Next slide. So just a reminder too, really quickly, if you do have questions for us, please do feel free to use the chat. We are happy to look at those. So when we're talking about ownership of the data and the work product, again, these are similar issues. A lot of these AI tools take very aggressive stances on what that ownership, that data ownership looks like, including with regard to what we refer to as inputs and outputs. So what goes into the tool and then what comes out of the tool. And so again, many times these licenses, these data rights aren't specific in the documents. And so it's really important that you understand, to the extent they're not there, that you may be giving those rights away. You might consider the outputs to be part of your confidential information, to be part of your customer data, or your vendor data if you're the vendor. So depending on your status and your relationship and what the tool does and what those inputs and outputs look like, you may need to specifically address those in the contracts. And so Courtney, talk to us a little bit more about what that looks like from your perspective as well, and what you've seen in terms of the different tools that this might be an issue with, and how we think about this a little bit more.
Yeah, I mean, I think one of the things we really have to grapple with, and this is, again, it's not new to AI, but I think it's coming to a head with some of the newer applications of AI, and that is that there's times where you're going to kind of wonder, what am I buying? What am I buying here? Because you're going to hear a lot of, you don't own the model, you don't own the training data, you don't own the improvements, and it's going to start to be frustrating a bit because, what are you paying for then? And I think what you have to think about is starting to mentally make the change in your head about what it looks like to focus on things like control, use rights, future optionality. And again, the only way to do that, to kind of split those hairs, is to understand all that context we talked about before. So, general ownership may not be possible in the context of how this vendor has set up their tool, but you understanding exactly what's going on with your use of it and what control you need to be effective at solving the problems you and your business have discussed, that's when you can get that, those type of terms that you need. And then the other piece of it is, if you're not going to get things, like you're not going to have ownership, or you're not going to have certain pieces of it, instead you're only using use, for example, then that's where you really have to get those strong indemnities and warranties, right? Because they're saying, hey, we're going to own it, you aren't. Well, then, okay, then the benefit of that is you have to protect me, because if I don't get to own it, I need to know that I'm taking care of. So you kind of just have to do what we always do as we negotiate deals, right? And that is kind of reframe the discussion for what matters with your particular business. So I would just think about it. It's not unlike other data rights in the past, but I think it's probably even more so around things like control and understanding your use cases. And then what do you think your future optionality is? What's their future optionality? What are you comfortable? Knowing what you know now and what you don't know, which is probably a bigger set of information. What are you and your business comfortable with, and what would that look like? So that's the way I'm thinking about this space.
Right. And interestingly, we just got a question that's right on topic. In other words, this question though is sort of more about after adoption, are we afraid we're going to have increased prices sprung on us? And I think to Courtney's point, the idea is maybe, how do we anticipate that? Are we going to have a tool that has, articulated fee structures in it? Not all of them do, to the questioner's question here. In other words, you could very well, and I have seen, now the examples that I've seen have not been for products that I've recommended my clients move forward with, but cases where the vendor asserts that they can change terms, policies, including privacy policies and services agreements unilaterally and without any notice. Obviously, I don't think that's a situation that we would recommend any business partners, clients, anyone get into. So that's obviously one very extreme side of the spectrum. But there are AI vendors that have those terms. And then there are AI vendors that are very much like other service providers. They will absolutely agree to robust enterprise service agreements. They will agree to robust data processing and business associate agreements. They have robust privacy policies. They will set discrete fees for specific periods. And so to Courtney's point, it's about weighing the terms that you see versus your expectations of the tool and the use cases and trying to figure out where there may be gaps, and you need to anticipate those gaps. So next slide. So
I just wanted to answer one more
yes,
piece
please.
to the question there is about, sort of feeling like what I think I hear the question is, we're going to be heavily dependent on particular AI providers, build on top of it, go after solving problems for our customers. Who's to say they're not going to later just increase the prices, in which case it's really tough for us, right? Because we're already dependent on them. I think that's what I hear in this, and it's a good question. I think there's a lot of analogies back to software and hardware that was very similar for key pieces of technology, whether or not that was particular chips and things like that in hardware or core technologies that different software would run on. And I think there's a lot of different ways to look at it. But what I would say is you have to step back and have a procurement strategy that addresses that. And that really comes to whether or not you're dependent on something. And I would think of it as a resilience activity, actually, and thinking about not just if they increase prices, but if something goes wrong with that particular technology, how is your company going to respond and how quickly can they respond? And that's where I think you can build in very similar activity you need to do from cyber perspective, thinking about the resilience. And when you do that, you're thinking about resilience from a supply chain protection perspective. And some of that is, and I know this is hard to do, sometimes you have to run more than one tool if it's a central function. And you need to have, people on different tools. That's difficult to do, but it can happen. Another area that can be very helpful is to get clauses that make sure that the A team of the vendor has to be there if problems are happening, not just the C team. Another is that if you have to transfer off of them because they do hit a threshold of cost that is not able to be handled by your particular company, how much time do you have to switch to someone else, and what obligations do they have to support that switch? Because in those cases, it's not that you don't want to continue with them. You're saying economically, I can't afford them anymore, in which case that I think is very fair to say, well, I want a reasonable period of time to no longer be dependent on you. I don't want my customers hurt. So this is, that's 30 days, 60 days, 180 days. Again, it depends on what the technology is, but asking for that to me is completely appropriate. If in your context discussions, you are talking about something that is central to your customers, central to something that could cause problems for your company, then I would absolutely build in creative clauses that force them to at least work with you if certain thresholds are hit. And again, that's, if you can't run two tools or whatever it might be, I understand sometimes you can't, then I would try to find ways to mitigate it through clauses like that.
Yeah, absolutely. Great point. Thank you, Courtney, for making that point. I appreciate you jumping in. I think the idea is that in some industries, some of this is highly regulated. So like in the healthcare industry, if we're talking about EHR vendors, for example, they are highly regulated. These types of vendors are not regulated in that same way. And so some of these issues, to Courtney's original point, when we started this discussion, we must address by contract, but because there's just not a good way to rely on state or federal regulation yet to address these really crucial issues. We've included on the next couple of slides some initial questions. So obviously, we've talked about additional questions, particularly in the governance context, that you may want to ask as you're starting to have these discussions. But, some initial questions that sort of prompt those discussions, including with your team. So this slide is just really sort of starting to have that conversation with your initial team. What does this look like? And then on the next slide, please, Janine, some initial questions to ask the vendor. And as you're putting together your sort of questions list, so that you can make sure that you don't forget your questions as you're working through questions, both for internal governance processes, coordination, use cases, et cetera, or when you're putting together any lists, including, security questionnaires, privacy questionnaires, whatever your normal and standard process is with vendor onboarding. These are questions you may want to consider adding to those processes, both internal and then external. So you can have a good picture, again, internally for purposes of your discussion. And then once you start your conversations with the vendor externally, whether those conversations are on the low risk end and what you're sending them is paper only, or if they are on the high risk end and you really need to have, some meetings with their legal counsel, have discussions, whatever that looks like. Next slide. So we got another question that is about whether or not there's sort of an online playbook for these types of contracting issues. I sure wish there was. I'm not aware of any yet because a lot of these issues are just so new. We are seeing these robust AI discussions over the last year, I would say, maybe a little bit longer. We have started to see robust state regulatory development in certain states with regard to notices to individuals about how how an AI tool may affect them and their particular rights. But we haven't seen additional robust creation of legal frameworks, for example. So we're sort of working with the legal frameworks that we have, modifying our internal governance processes as we've just been discussing, and then modifying our external contractual vendor onboarding processes as we've also been discussing. And unfortunately just haven't seen really any good online materials from my perspective, but I don't know, Courtney, if you've seen anything. And then also, we were curious from your perspective, but Courtney, jump in here really quickly before we sort of ask this final question.
Yeah, I mean, I think there are some online options. Like if you look at IAPP, I think there's ways that they've added certain ways to add to your privacy assessments for AI. Look under PLI. I think they've started to do some of that work. They have a great licensing annual session that they do for CLEs. I think they've started to add in more materials related to AI. So there's a few of those things. I don't know that it's perfect in a perfect book, but there's definitely some things out there for you to pull. And a good time to go to your outside counsel and ask them to pull it for you as well, because there are a few where they've been listing some of those. So there's some stuff out there. I don't know that's a perfect book. But and then what I would say is there's an element of wanting to do playbooks everywhere. And I think that is true in some of the baseline, as long as you're thinking about how fast this is changing. So, doing some
Yeah, great point.
playbooking and sort of, creating it for you and your teams makes sense to me. But I'd be careful to rely on it too much because things are evolving fairly quickly. So make sure you think about writing in the dependencies. So for example, if the law develops this way, then I would have to look at this clause again. I would build that in if you're going to build out kind of more full playbooks, and just be careful when you grab them from some of these sites, because I really think the real trick here is the nuance that we talked about in the beginning. It's the context. And so while I think they can help you at the base, I think figuring out what's most likely to happen in your business, what you're really trying to accomplish, is how you're going to then create a contract that protects the spirit of the deal you're trying to do. So, they always have a base help, but I do think there's some pieces you can pull out there. But I would be careful as you apply them.
Yeah, no, thank you. Thank you for pointing that out. I think that's a great suggestion, but also totally agree that as with anything, nothing is one size fits all, and these pieces are changing so quickly that we must always keep that in mind. We were going to sort of try and talk a little bit more about this, but we're kind of running up against time here. So something to think about yourselves as you're going forward, kind of what you're finding most challenging. These are very challenging issues: data rights, training use, permitted uses and use restrictions, making sure that we have humans in the loop and accountability for the use of these tools, auditability and transparency, liability allocation and caps, as we've been talking about, is a huge piece of this discussion. And then just the overall third party or sub-processor risk. I mean, obviously all of these we've talked about a little bit in this discussion today, but should be sort of highlights as you are thinking about how you are using these tools in practice. Courtney, do you want to add anything before we sort of move to the next slide and wrap up here?
Yeah, just one thing. I think when we talk about data rights and how data is flowing, and it was a good example earlier when we talked about the fact that you could be buying a vended tool, but then they could want your de-identified data. All of a sudden, it's really a two-way transaction. And I see that increasingly in anything that involves data, which what's happening? Almost everything involves data. When that happens, as lawyers, you have to have flexibility in thought. And what do I mean by that? You need to think about yourself sitting both as the customer and as the supplier, right? And in each of those cases, you want something different in these terms. And so depending on what the flow is back and forth of value, you need to make sure that you're thinking flexibly about it. Early on, when I went to Motorola, we had teams very separated between the lawyers who supported supply chain and procurement and the lawyers who supported the customers, and those two things never mixed. And it was really a shame. Eventually, we did bring them together, and not only did the lawyers love it, but suddenly we were a force to be reckoned with, because now we could really negotiate on both sides of the deal, and we knew exactly what the other side was thinking because we had sat in their seat. I think with these data deals, that's the kind of prep you need to do. So when we say context in the beginning, we also mean you need to be thinking about what is the answer from the vendor for all of the things we talked about, and how would they view it from their eyes? And is it going to come up where you're going to want something because there's a part of the deal where you actually sit in their shoes and you supply them something? And is that consistent with what you're asking? So that's the kind of the fun part of data deals. Intellectually interesting part is that you have to think through it. And these tend to be the ones that are on the slide right now, the areas where you have to think about flipping back and forth on why they wouldn't like it, why you would want it, what's really fair in the value system, what's the strategic justification for it, because it can't always just be, well, I want it, or the law says so.
Right.
These are strategic partners, right? So you got to have justifications for why it makes sense. One way to do that is to try to, walk in their shoes and think about it both ways. So just encourage you to think about that, because I do think data deals and things that involve data and most of these AI tools over time will continue to be a two-way street, and they won't be as linear as some of the other vendor relationships that have been in the past.
Yeah, nope, totally agree. It's definitely a game of chess, not a game of checkers. So thank you so much, Courtney. Thank you all for joining us today. Again, if you have questions, please feel free to get in touch with either Courtney or me or both of us offline. We are more than happy to help. And Angie, we'll toss this back to you.
Thank you, Ileana. At this point, we'll conclude this program and today's AI conference. On behalf of the chapter, I'd like to thank our sponsor, Polsinelli, and panelists Ileana and Courtney. To obtain your Virginia CLE form for the conference, please look for an email from Beth McConnell within the next few days with a link to the form and a survey seeking feedback about today's conference. We hope you'll complete the survey to provide input about the conference and your interest for future programming. Thank you so much for joining us for the chapter's first AI conference today, and we hope to see you all soon at another ACC NCR event, including our upcoming Corporate Scholars Reception in DC on June 4th and our Corporate Council Awards Reception in Northern Virginia on July 15th. From my perspective, it's been a fantastic day, and we really want to express gratitude for everybody who's been involved in making it happen.